Ethical Perspectives on the News is produced by the Interreligious Council of Linn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Good day, and welcome to Ethical Perspectives on the News. My name is Linn Tabak. I will moderate today's discussion. Our subject is how we choose the people who protect the law in our state. There's some proposals to change the way we select judges for Iowa's courts. To help us explore this subject, we have three guests today, all of them attorneys, I think, right? On my left is Paul Gowder, who is a professor at the University of Iowa's College of Law. And Bob Rush is at Rush and Nicholson, a law firm here in Cedar Rapids. And Steve Pace is at Shuttleworth, Ingersoll. Is that right?
Correct.
Okay, so I'd like to hear a little bit from each of you about your involvement in the community and in the law. So why don't we start with your teaching? Tell us a little bit about your career and interests.
So I teach constitutional law at the university.
Okay.
I'm a former civil rights practitioner, actually. Not here. I still haven't gotten myself joining the Iowa bar yet. I do research on actually this idea of the rule of law, of what it means to hold the courts and the people accountable to the Constitution.
Very good. And how long have you been at the university?
Oh gosh, this must be the end of my 7th year here in Iowa.
Very good. Okay. Bob and I have shared roles in this conversation before. Tell us a little bit about yourself.
Just Paul's introduction reminds me I started in civil rights work, specializing in voting rights across the South in places like Mississippi and Alabama and Georgia. So I was exposed to a lot of different courtrooms in a lot of different states. Okay.
And Steve?
I've been a practicing attorney here in Cedar Rapids since '77. I went to Iowa Law School.
Okay.
And,
good choice.
Thank you. And I was a trial lawyer at the beginning, and I've done a number of things. I do environmental law now, but I was also on the Judicial Nominating Commission, the statewide commission, from 2006 to 11. And it was an interesting time because it was 3 different governors during that time, and 3 different chairs of our committee, 3 different justices. And I think we met almost a dozen times. There were so many vacancies. So we had a lot of different experiences during that time. And it's that's brought me into interest in this, as to how this works. And I have some opinions about how I think it works now, how it worked then and works now. So
you've helped select judges for us.
I have.
Okay.
Yeah, I looked up in the current Supreme Court and Court of Appeals, and our commission selected about half of each.
Oh.
Okay.
So far, they're still there. About half of them are there, and some have retired. Some have been voted out since then and replaced. And I was part of the group that did the 3 at once. Okay. That was an interesting process as well.
So I think our audience might benefit from an overview of what kind of courts we have, how they're related, the roles they play. I'm new to this subject, so you'll be educating me as well. Give us a little overview there, any one of you.
Well, we have various layers of court.
Right.
District court is what we think of as the trial level.
Okay.
There's a small claim court underneath that, but by and large, district court, then Court of Appeals, and then the Iowa Supreme Court.
Now what about different kinds of cases, civil, criminal, family, juvenile, those kinds of distinctions? Is that
We have a unified court system in Iowa. In some places they have family court, or they call it matrimonial court some places.
Okay.
They have a separate criminal court, separate civil court, separate equity court, separate law court. Our courts are unified. They hear all cases. So one judge might hear a criminal case one minute, divorce the next, criminal matter the next, civil matter after that.
So it'd be the same judges involved in these different kinds of cases. What about, say we mentioned appellate courts and Supreme Court. Could you describe the role of those courts for us to make that clear?
Well, sure. I mean, the fundamental idea is that, trial courts hear witnesses, trial courts, district courts in Iowa make the initial decision, but the courts of appeals are there, partly the Court of Appeals of the Supreme Court, to correct mistakes, particularly legal mistakes down below, and to sort of keep the law, keep the application of law consistent across Iowa's many courts.
Okay. So why don't we now try to help our audience understand how we select judges under the current system and how this method originated and what some of the reasons were for creating this system many years ago. Who would like to help us
We
there?
should have our experience.
Let me start since I'm the oldest. When I was a kid, judges in Iowa were elected.
Yeah.
Somebody wanted to be a judge, you had to run for office, you had to solicit campaign contributions, you had to campaign. Virtually everyone across the state recognized that's a lousy way to decide cases. And in time, in 1962, I think it was, we passed a constitutional amendment to take selection of judges out of partisan politics, make it a merit-based system.
Okay. And you've served on this commission, so tell us what the commission is, how it's composed, how it does its work.
Half of the commissioners are lay people, not lawyers, that are appointed by the governor.
Okay.
And they're geographically diverse. That has to be from different parts of the state. It's also, there's a gender diversity. It has to be half men, half women.
Just for the governor's half? Or
no, for all of them.
For all of them.
And then the other 8 are lawyers that are elected by lawyers in what were the congressional districts in 1962.
Well, we've changed that.
Which was, and then but it's in a congressional district, and so lawyers within that district then vote for the lawyer members.
Okay.
And then one of the Supreme Court justices, not the chief, but the next senior, is the chair of the committee.
Okay.
And the court administrator for the Supreme Court also sits in on those meetings and does background checks on the candidates and gives us information about the commissioners.
And then Steve's hard work on the commission, their job is to pick out the best and send 3 names to the governor, and from that list of 3, the governor would pick someone for the Supreme Court.
1. And Court of Appeals works the same way.
Okay, so I'm familiar, as I think many of our audience might be, with the battles we've had over nominations to the United States Supreme Court, where there's a lengthy and now increasingly fractious confirmation process in the United States Senate. So as I understand it, the governor then picks from this list that she's been given, and we do not have that kind of debate within the legislature that we see in the Washington, D.C.
And I think that's widely considered to be one of the key advantages of the commission system, is that really the 2 alternatives are, number 1, appointment by elected officials. And as you said, we've seen in a country like ours, including in the states where we have what's understood as really strong judicial review, where the courts get to do things like strike down laws and find constitutional rights, which the U.S. is really the strongest example of that. If the courts are politicized, if we directly have political officials appointing judges, or if we directly elect them, what we've seen is that it tends to make the process extremely partisan, and this is exactly what we've seen in the U.S. Supreme Court.
So another small detail here, you said that the governor is appointing lay persons to the commission. Is she free to include attorneys among those? Is it just a freedom to select anybody, or is she obliged to exclude members of the legal profession?
Well, I think she can pick anyone.
I think she could pick anyone, but in practice, since the lawyers are elected and half are lawyers anyway, they tend to select lay people that are not lawyers, and probably not surprisingly, from their own party. So at this point, for example, all of the lay people on the commission are Republicans, and 3 of the lawyers that were elected are Republicans.
Okay.
And as I said, I was on the commission. There were 3 different governors, two Democratic governors and 1 Republican, and there was some mixture of parties. But frankly, party politics didn't come up. No one was asked, what party are you? In fact, when somebody asked me later what was the party affiliation of the people that were on the commission when you were there, I had to say I wasn't sure, because we didn't discuss it. It wasn't something that was relevant to anybody, and it probably would have been considered improper to have discussed that. That's not, and the governor was not involved in influencing commissioners. That was forbidden and doesn't occur. And if that were to occur, they would report that to the Supreme Court justice that's chairing the committee, and that would be taken care of. That did not occur in the 6 years I was on it. Quite surprisingly, maybe to some people, but that's because it's not supposed to be a partisan exercise. It was who are the best candidates, who are the most qualified, and I can say that at times we sent up the commission I was on sent up some very conservative people and some very maybe perhaps liberal people, and people would say, well, why'd you do that? Because they were the best candidates. And you have to understand it's whoever's running. I mean, they have to put themselves up there. What is the mix that's there? And some of it's geographical, some of it's age, some of it's lawyers as opposed to judges, as opposed to attorney generals, as opposed to public interest lawyers. So there was a mix of that kind as well. That's more the discussion that one has.
Yeah, and I love hearing this, because so I'm the one person here, I think, who is not a native Iowan. I've only been here for 7 years, and Iowa has this reputation in other states as this sort of font of civic virtue, squeaky clean system, careful administration, really just incredibly ethical judges, all of these commissions doing their work very carefully, and this just really bears that out.
Well, it reminds me of when I'm new to the subject, just reading about it in preparation for this show, but it reminds me of our pride in the way we draw district lines for congressional districts, right? Iowans take some pride in having made that less political than other states. Am I right there, or am I? Oh,
thank you. That's a topic for a whole full session.
You want to contest that claim?
No. I was the co-sponsor of the law.
Okay.
So.
Oh, very good.
It's one of the best things we've ever done in Iowa.
So is that a fair comparison, that this system was created with the same kind of intention? Is that fair enough?
Yes.
Yeah. Okay.
I think. The people that were behind that constitutional amendment in the early 60s had been exposed to political judges, and they saw the shortcomings of a system where judges were these partisan elected people presiding over cases, and the change was enormous for the state, and Iowa, our system is recognized across the country as one of the best in the country on judicial selection.
Okay, well, let's give our audience an understanding of what's been proposed and what we think might be the motivation for challenging a system that's been in place for more than a half a century.
Well, they want to dump the merit system and replace it with a political grab, politicians controlling who's on the nominating commission. And the current lineup, what they would propose would result in 12 Republicans, I think, on the commission and 4 Democrats. It's a political grab. There's no confirmation by the Senate of commissioners, as Steve would have been confirmed by the state Senate once he was.
Lawyers are not. Lay people are confirmed by the Senate. The lawyers are not. That's right.
And so it's an unfortunate 180 turn that rejects the wisdom of the constitutional amendment that has worked so well for over 50 years.
Well, let's be specific about the proposal, though. So the leadership in the legislature would then select half of this commission. Is that my understanding?
Yes.
Yeah,
So the leadership is not voting directly on judges. The leadership of the legislature, the people's elected representatives, are then selecting the members of this commission that selects the judges.
Half of them.
And the leadership means that in the present case, where Republicans have majorities in both houses, they would have the majority of that leadership positions. But in some future year, when it flips, then Democrats would have the advantage for a while, and so on.
Sure,
right?
exactly.
Okay.
Right, the governor picks half, I think, under the new proposal. And, you know, there's a Senate bill and there's a House bill, and they've been amended. But I think, as last time I checked, I think the governor would appoint half, and then the leadership in the House and Senate would appoint the other half.
And one further weakening of the ballot system that we have today, the governor's appointees would not be subject to confirmation by the state senate. The current system requires confirmation. It's an extra check on the balance of the system.
Has that been difficult in recent years? Have
No.
the governor's appointees been
Generally,
controversial?
generally deference has been to the governor.
I don't recall one that was ever turned down. Do either of you? I don't. There may have been one, but not. It's very, very rare.
It's been
I can't
years,
think. I mean, I've never been. We haven't been here as long as you guys, but.
We may have turned one down back when I was in the Senate, but I'm sure there were good grounds for that. But always deference to the gubernatorial choices.
So this proposal is coming from the Republican side in the
Yes.
legislature?
Very much so.
So tell us where the who was putting this forward, where the support is, and
Well, the underlying theory here, just to sort of get that out on the end, I think, so this is a proposal that's been raised in a number of other states by conservative groups. There's a group called Americans for Prosperity that tends to get involved in these. And the theory under which these groups have advocated, and which I think the Republicans in our legislature have accepted, is that selection by lawyers in particular leads to judges that are more liberal than other kinds, on the theory that lawyers are more liberal. And so that's really the motivation. That's been the sort of the argument that Governor Reynolds and that the Republicans in the legislature have been raising all along.
There's a PAC, there's an organization in the state that is theoretically organized around religion. Their mission is primarily political, and they are driving this particular legislation. Gay marriage is a big issue for that particular segment of the population, and they don't like the decisions that the Supreme Court has handed down, and they think we've got to get this court back in the hands of the elected officials.
okay.
And one of the things that I think is we need to point out is that the judicial branch is a branch of government. It's not an agency. It's not supposed to be an agency that is responsive to political whims, and judges don't take polls to decide their cases. They decide their cases based on the Constitution, the law, precedent, and the facts of a particular case. And I'm not sure that's well understood. People tend to think sometimes judges just decide what they want and make it come out the way their personal feelings would be. How many times, Bob, have you had a judge say, I hate the result that I'm going to have to make here, but I don't like it, but I'm compelled by the law, by precedent, and by the facts to decide this case this way. That's true in criminal cases, it's true in civil cases. It's not always what the judge wants, but it's what the judge is compelled to do by virtue of the rule of law. And that is something that judges take very seriously. And Professor Gowder would know that. I mean, as it relates to how they do it other places, I think that's generally true of all judges.
I think that's absolutely true. I mean, in a lot of ways in Iowa, I think so, you know, in one of the standard stories, and actually we were talking about this a little bit before we began, one of the standard things that people like to talk about is, you know, out-of-touch elites. And there's some worry that judges making constitutional decisions like the gay marriage case are somehow out of touch, and that has something to do with liberalism. I mean, if you know the people on the Iowa Supreme Court, right, I mean, you would laugh at that. You know, the people on the Iowa courts in general are, for the most part, lawyers with really strong roots in Iowa's legal community. You know, they're not like Yale grads from out of state, right? You know, these are like Chief Justice Katie went to Drake. A lot of them went to Iowa, where I teach. They're lawyers elected. The Judicial Commission, the lawyer half, is elected by local lawyers out in practice in the community who understand what the judiciary needs to do to serve the interests of law across Iowa's communities. And in a lot of ways, it's more democratic than gubernatorial appointments.
Well, I'd like to test you all a little bit on this here. So, Bob, I'm also old. So I am old enough that when I was in the 2nd grade in Massachusetts, my school day began with a recitation of the Pledge of Allegiance, a singing of a patriotic song, and a recitation of the Lord's Prayer. And then we ended that. So in my life, I've seen a lot of big social changes that have come from the court rather than the legislature. And it's bewildering to me. The Congress begins with a prayer. They have a chaplain. Session of the Supreme Court begins with a prayer. But somehow, after 150 years of history, we decide that's wrong. And we spent all of my 12 years in public school debating about which song we could sing at the holiday concert and whether we could have an inspirational reading if it wasn't from a sacred text, and so on. And then we had the abortion decision when I was in high school, and then the questions on homosexuality. The 1980s, the court allowed laws prohibiting this behavior, and then 20 years later, 30 years later, decided there was a civil right to engage in this behavior. And so it's bewildering to me. It looks like that the picture I got in my 10th grade civics class about the legislative branch of government making the law was a bit of a fib. So go ahead.
Well, I think what your civics teacher may have missed out on was this Constitution and the co-equal branches of government and the role of the court in looking at the law and interpreting the law that the court is given, whether it's constitutional law or whether it's statutory law. And the only reason why there's ambiguity in statutory law is the legislature failed to address specifics that may arise under the law. So the court is doing its job. That's what the Constitution commands the court to do.
And to sort of go into one of your specific examples for example, as a nation under laws, really when you have an objection to something like the court saying that you can't have the teachers leading the students in the Lord's Prayer, the objection really is to the Constitution rather than to the courts, so long as the courts are doing the best job they can of interpreting it. I mean, yes, we have a debate about things like that, but it's a debate that we've been having as a legal debate for a long time. I'll give you an example. James Madison, excuse me, James Madison wrote a famous document, basically a nastygram to the Virginia legislature around the time of the Revolution, because the Virginia legislature was proposing allocating public funds for teachers of religion. And so the framers wrote their views on these debates into the Constitution. I mean, we can change the Constitution.
And I think that's a very good point, because people unhappy with decisions involving abortion or guns or whatever it might be, there are ways to change the law through constitutional amendment, through statutory change sometimes. So there are a lot of checks and balances.
So let me ask you about this. We just said that this current system was created through the process of constitutional amendment, and now we're trying to change it through legislation. How can we pass a law to change some? I don't understand that part.
I've been wondering about that, actually. So as I read the Constitution, it says elected from among the bar. How are they finagling that?
It's an actually very good point, and I was reading the debate. There was a transcript of the debate within the Senate when that bill came through, and some of the senators were making the point, you can't do this because it's in the Constitution quite specifically. And so to change the law and say we're going to amend the Constitution by statute is not permissible, and so it's unconstitutional to do what you're doing. It passed nevertheless. So whether it would then be challenged later on that basis, it seems like it might be. But I guess that remains to be seen. I want to make one other point, though, we haven't touched on, and that is that there is, and maybe we did touch on it, but there are elections of judges in Iowa, but they're retention elections. Right. So after a judge is appointed, and this is true of all judges, the first election following their appointment, they come up for a popular vote, and they can be voted out by the citizens. And then at the end of each term, they come up again for retention. And if the citizens vote them out, more than 50% say no, they are then not judges anymore. And so there is a overt check by the people of judges. And that's part of the system. It's been part of the system, and sometimes judges are voted out.
So we're down to our last few minutes. You might want to think about if there's a lesson you want to give our audience or before we leave. You might want to tell us if you have a prediction of where things are going to go from here.
It's interesting. There's a Register poll that said 54% of Iowans think the present system is better, is better than changing it. So there's 54% in favor of keeping it the same, and 33% in favor of switching it. And it makes one wonder then where the impetus for this change is coming from when most of Iowans don't want the change, and we've had it from 1962 on, but the Republicans are in charge of the legislature, and they're the governor is a Republican, and they all seem to be voting for it. So I guess my prediction is that it's probably going to pass, but I don't know that.
I think it's a very close call. I hope people are listening, because to trade in a merit system for a political system is the wrong pathway to go.
Yeah. Paul, you get the last word here.
I mean, I have no prediction. My political crystal ball does not work. But I can't see how anybody could look at the chaos in Washington around judicial appointments and choose to sacrifice what we have.
Can I just say the system we have works very well, and I hope we don't change it.
Yeah.
Okay, very good. Well, I've learned a lot in this conversation. My producers proposed this topic to me. It was brand new to me. I did some reading over the course of the last week, and I've learned a lot from you here tonight too. So I'd love to continue this for another half hour, but I think we're out of time here. And I hope you will all join us again on our next episode of Ethical Perspectives on the News. Thank you very much.